Ms. Iden?
Mr. Chief Justice, and may it please the Court. No party disputes Cooper's basic legal rule that absent a compelling interest, race cannot predominate in line drawing, even as a means to achieve a partisan goal. Here, the panel properly concluded that race predominated over partisanship in CD1's design based on strong factual findings, including that after map drawers moved more than 193,000 people in and out of CD1, its BVAP remained identical as in the 2011 map. In so doing, map makers sorted more than 30,000 Black Charlestonians based on their race, removing 11 of the 12 precincts with the highest Black voting age populations. This massive movement disregarded the least change approach that the state applied statewide, and that map makers admitted they abandoned only in Charleston County, which had been CD1's historical anchor. Disentangling race and party affiliation using the very methods this court accepted in Cooper, the panel credited the unrebutted expert testimony that race was a better predictor than partisan affiliation for the design of CD1. Under the clear error review standard, this court should affirm the panel's factual racial gerrymandering factual finding because it is more than plausible in light of the total of the record. Appellants also cannot show that the panel committed a legal error, particularly in its rejection of the alternative map requirement. Finally, the record here is indeed the inverse of Cromartie 2, where a majority of this court determined that map makers designed a district using political voting behavior over time, rather than relying upon racial stereotypes. Here, by contrast, the panel found non-credible the appellant's assertion that they relied on merely 2020 partisan performance data for CD1's design. I welcome the court's questions.
Counsel, we normally have an alternate map in these redistricting cases, and of course we don't have one here. In these instances where you have a high correlation between race and political affiliation, how would you constitutionally disentangle them?
We have something we believe that was better, if not comparable, to an alternative map. We have this unrebutted testimony of Dr. Ragusa. That testimony is corroborated by the testimony of Dr. Liu. If you look at the amici briefs of the political scientists who performed the analysis in Cooper, they validate that the methods that Dr. Ragusa and Dr. Liu used are the same as in Cooper. All of the pot shots that are made by the defendants in their brief about Dr. Ragusa's analyses and Dr. Liu's, almost all of them, nearly all of them, and I can walk you through them, were made during either discovery or during Daubert motions or at trial, and the court simply didn't reject them. It is unrebutted evidence disentangling race and party, which is a form of circumstantial evidence, but akin to an alternative map. If you look at Dr. Ragusa's rebuttal report, figure 1, he charts out all the VTDs in CD1, and he looks at whether the racial composition or the political composition determines their placement in the map. And you can see that 4 of the 5 heaviest Black precincts were moved out of CD1. By contrast, only 5 of the 17 majority white precincts were removed from CD1. And this is, again, unrebutted testimony, and it serves the purpose of an alternative map because this court unanimously in Desert Palace said that there is no particular form of proof a plaintiff needs to show in an equal protection case.
Counsel, we have said that the burden that you're assuming of disentangling race and politics in a situation like this is very, very difficult. But it is your burden, right?
Yes, Your Honor.
And you're trying to carry it without any direct evidence, with no alternative map, with no odd-shaped districts, which we often get in gerrymandering cases, and with a wealth of political data that you're suggesting your friends on the other side would ignore in favor of racial data. Have we ever had a case like that, with that combination? We usually are looking for those sorts of things, and we have those. Have we ever had a case before where all it is circumstantial evidence?
I racked my mind, and I think the closest we might come to it is a case like Gamillion, where plaintiffs would have lost there if they had been required to have proved by direct evidence, where the circumstantial evidence was overwhelming. But here, if you're asking whether there's direct evidence that the legislature admitted in the 21st century that they sorted voters on the basis of race as a means to achieve their political goal, no, we do not have that. But what we do have is the factual finding that the map makers had maptitude data with race data.
Well, I understand that, and there's a lot of back and forth on it, and you certainly have the clear error standard in reviewing that. But we've never had a case where there's been no direct evidence, no map, no strangely configured districts, a very large amount of political evidence, whether the district court chose to credit it or not, and instead it all resting on circumstantial evidence. Circumstantial evidence to determine what we held as recently as in Allen last year is something that is peculiarly in the province of the states in drawing the districts. I'm not saying you can't get there, but it does seem that this would be breaking new ground in our voting rights jurisprudence.
Respectfully, I disagree. I mean, we have strong, this is not Cromartie, we have strong circumstantial evidence where we're not relying upon, the court did not rely upon foregone alternatives or conclusions about what happened. We have a racial target, that the fact that the Senate was proposing various maps over the legislative process and moving 193,000 people around, and they can only explain it as being by coincidence. The fact that the question in a Shaw case is whether there was a significant sorting of black voters on the basis of race. We have 30,000 Charlestonians moved out of CD1, out of their home county. It cannot be explained by least change, the priority principle that they said was guiding their map for much of the legislative process.
Sorry to interrupt, and that is to change the voting percentage in that district by how much?
Ultimately, it was by 1.36%, and Senator Kempson used that 1.36%, the lead sponsor, to disclaim that this was a partisan gerrymander during the legislative process. So the court accepted that they had a legitimate means to achieve this political goal. We don't dispute that. The court accepted that they had this preference to bring in political counties. But what the court acknowledged is that when they brought in those counties, there were black people brought in alongside with them. That then led to an increased BVAP in CD1 that became too politically risky. And for the black people they brought in, they offset the black people by expelling them from Charleston County. And that goes to the heart of this court's jurisprudence of using race as a means, even for a legitimate political goal.
Well, it's not, just so I understand correctly, this is not a voting rights case, right?
This is
it's a gerrymandering case, right? And they did all of these things to increase the percentage of the voters they wanted in that district by 1.6%?
1.36%.
1.3%.
You're close enough. But
you had,
whether...
I'm sorry.
Yes.
You had 4 sophisticated experts, right?
Yes.
Is there any reason why one or more of them could not have drawn up an alternative map that met the legislature's stated partisan goal but had a different effect on the racial composition?
Because once again, we think that we proffered evidence that was as good as, if not comparable to, an alternative map.
But you admit they could have done that. It wouldn't have been a big burden for them to do that.
Well, I
and they
would
didn't do
submit
it.
that the legislative record reflects that the partisan justifications did not become clear until midway through trial. For most of the legislative session, most of discovery in the case, the enacted map was defended as being compliant with traditional redistricting principles.
I mean, this whole case is about disentangling race and politics, right? That's what the whole case is about.
But the justification for the map was largely based upon traditional redistricting principles until trial. Then at trial, the lead counsel says this was about partisanship. This was about, and the map creator says, I was instructed to make this a Republican-leaning district, and alternatively, it's traditional redistricting
I didn't mean to interrupt.
principles.
Until trial, you thought that the state was going to defend this without making the argument that this was done to increase Republican chances in District 1?
Yes, Because
Really?
it was not in the guidelines for the legislature that they were achieving a political goal. There are statements that we have included in our brief that outline that people were disclaiming that this was about partisanship and this was about. But even
You didn't see that in the discovery. You had very extensive discovery.
there was people during.
They didn't say the discovery doesn't. The members of the legislature in the discovery didn't say this is what our aim was.
If you look to the testimony of people like Mr. Fiffick, Mr. Torini, these are counsel for the staff. They were all disclaiming in the lead up to trial that this was about partisanship.
And in fact,